this next topic is, I like to think it's simpler. It certainly takes me a shorter time to walk through it, and I think it's a little bit more fun and it's a little more relatable, okay? So today we want to talk about water shares versus water rights. So a share versus a right. Is there a difference? If there is a difference, what is that? So I'll at least walk you through what we decided to give to you today, okay? So a water right is real property established under Title 73 of Utah Code. It entitles a water right owner to divert and beneficially use waters of the state within the limits of the right. Another interesting thing about water rights, it's already been touched on multiple times today. And it was green before. Okay. Green, red. How about now? I reset it. Green, red. Check, check, check. It is green. Okay. Is it good now? How far back do they want me to go to the beginning? I'll make it short. We're going to talk about water shares versus water rights. Okay? Gall, I hope not. No one has time for that. Okay, we're going to talk about water shares versus water rights. So my big headers there were water right is real property established under Title 73 Utah Code. It entitles a water right owner to divert and beneficially use waters of the state within the limits of the water right. Okay, then what I was just getting into was that water rights are pertinent to the land where they're being used, okay? And so as has been mentioned before, if you have a field that you're using water on and you sell that field, that water right goes with that land sale unless you specifically withhold it in the deed. And as also has already been mentioned, the county recorder's office is the official office of record of ownership for perfected water rights, not us. We do not change water right ownership in our database until we receive the proper documentation, which includes deeds from the county recorder's office. Okay? So, a share. What's a share? If I could try to sum it up in the simplest way possible, you got to think of a share as a lease agreement between you and someone who actually owns a water right. Okay? It's a lease agreement. So there are these companies out there, irrigation companies, water companies that own a portfolio of water rights. They divide that water right up into interests. I don't know that they're necessarily equal, but interests, okay? And they sell those shares or give them out to individual people. And when you have that share, it entitles the shareholder to a proportionate share of the water in the water company within the limits of the company's water rights. So again, the company's water rights still define where the water can be used, how it can be used, okay? Typically speaking, shares are not pertinent with the land. You can sell your field off that you've been using irrigation company shares on forever, and the person who bought that land isn't going to get your shares. Very commonly, that's the way it goes. You can keep the shares or sell it with it, whatever you want. So in the end, the company is the official office of record of ownership for the shares. Again, not us. So let me give you a couple of examples about some common confusion and questions that I get asked often. This time of year, generally speaking, irrigation companies are sending out their yearly assessments. So essentially their fee to you as a shareholder so that you can use some of their water. I love the phone calls I get. Someone on the phone very upset, wanting to know why we're charging this inordinate amount of money to them for them to be able to use their water. Start trying to figure out what they're talking about because we do send out a lot of mailings. And I come to find out you don't own a water right. It's not us. You have a share in an irrigation company, and that irrigation company is billing you for their annual assessment. If you have a problem with the amount of bill or anything about it, you need to talk to them, not us. We don't have anything to do with it. Okay? Another really common example is when people call and they are talking to me, they'll use these words interchangeably throughout the conversation. I have a right to the river that my grandpa got, and we used to have to fight all the time with so-and-so about whose share went where and how much of this ditch did you get and things like that. And I have to work through them and ask questions to determine, are we talking about a water right or a water share? Because what I have to tell you is very different depending on which one you have. Another really common call that we'll get, on streams of the state, rivers of the state, if I have 2 water right owners on a creek, as the state engineer's office, we can make sure that the water right owners on that stream get the water owed to them under their right. You have distribution engineers, river commissioners to make sure that takes place. Where that dynamic changes is when I get calls from someone that says, I'm on such and such a canal, I have this many shares, I know the guy with the head gate just above me has half as many shares as I do, but he's watering twice as much ground. I want you guys to come down here, turn his head gate down, tell him he's got to take those fields out of production. Wait, so we don't regulate the canals once it gets into there. Once the water goes through their diversion, we're done regulating them. So if you have a problem or a dispute between shareholders, that's a civil action or something you need to work out with the company, but not us. Again, you see there's a lot of really important differences between a share and a water right. Okay? So again, water rights, real property. A share is a lease agreement between you and someone who owns real property. Okay? So, what's common, and this is what the rest of this presentation is about, very common for shareholders, though, to do something more with their water right than what that company typically offers. And so, essentially, you want to come in and file a change application with us with a share. Not a water right, with your shares. There is a way to go about this, and I'm going to work through with you some of the steps that you'll need to go through, all right? So, first thing to do is prepare a proposed change application. Put together what it is that you want to do. You got to go to the company, water right owner, with that proposed change application and pretty much say, this is what I'd like to do, would you guys sign off on it? And you got to work with them to resolve any issues or concerns that they have. That's the simple summary of what you've got to get done. We're going to go into a little bit more detail about it, okay? So, and again, let me give you some examples. You may be sitting there and like, why would someone want to take their share out of a company? Common examples that I see is people own shares in a specific drainage with a company. They build a cabin higher up in that drainage. That drainage is not open to new appropriations, but these people own a lot of shares. And what they ask is, hey, can I take one of my shares, move it up to my cabin, and pull the water out of a well or a spring that's on my property? That's a type of idea that a shareholder may have that they want to do with their shares. You may also want to just change how you use your water. Again, you can only use it within the limits of what the company's water right says. Maybe you have a big ditch and you want to run your water through a water turbine to generate power with your share water. Again, the company's not approved for power generation. So if you would want to do that, you'd have to work with us to get that approved. Okay, so there's just a couple of examples. So, shareholder prepares this application. They're going to go to the company with it. What are some things that you should have? You should be able to have your stocks that you're proposing to put into this, or your shares, right, that you're proposing to put into this change. You should have those. Okay? A description possibly of the land that you're going to take out of cultivation. Again, if you want to move the water from farming up to your cabin, some part of your farm has to come out of production for that water to go somewhere else and be used. An agreement that you give to the company, say, hey, even though I'm going to move this water, I'll continue to pay all of my assessments and fees and whatever comes down the pipe. And any other information you feel like might help the water company make the decision of whether they should sign off on this change or not. Okay? So, what does the company have to do? And I just want to highlight, this is the current statute. However, this timeline is slated to change next year. Will be shortened. But currently, the company has to respond to you within 120 days in writing. They could possibly give their consent. They could give their consent but with some specific conditions. Or they could decline, and they'll describe the reasons why. It's kind of interesting as we talk about it this way. If you think about our earlier presentations we've had, it's almost like as if the company is acting as the state engineer for a minute to decide whether they're going to sign off on this. If they don't respond in 120 days, it is deemed as consent, okay? So, The company could consider a lot of things when they're trying to decide if they're going to approve your application. Is it going to cost them money? Is it going to interfere with their ability to manage the system? Do you have enough shares to do what you're saying? If they do this for you, are they giving you preferential treatment compared to their other shareholders? Will it impair the quality or quantity of water in their system? Will it violate statute or ordinances or regulations? Is the ground you're proposing to take out of use, is that even possible for you to do? And any other cumulative effects that may concern them. Okay. However, with all that considered, they cannot withhold consent if whatever their issues are can be reasonably mitigated without cost to them. And they could charge you, do whatever it is that you want to do. Those are both options. Okay? So, you worked with the company, got them to sign off on the change application. Now what do? You come to our office with that change application, many of the similar documents you deliver to the company, and you file a change with us. And it's going to have to go through the exact same change application process as has been described earlier today with our office now. Okay? Specifically, you need to provide with that change application what you got from the water company. So either their consent or an affidavit saying they took longer than 120 days to respond to you, or possibly your issues with the company went all the way to a court case and the court order saying that you can do what you're proposing to do. Okay? So after approval, a shareholder may submit extensions of time without company involvement. So as has been talked about earlier, maybe it takes you a while to get this project done. Every time you need to file an extension, you don't have to go back to the company and get them to sign off on it. However, when time of proof comes and you need to submit a proof, the company has to sign off on the proof. Okay? Yeah. Got a question over here. Yeah, I'll try to. Forward, this one right here?
Yeah, so a canal company has a canal with 40-second feet going through it. And you asked to take your shares out of it, so you're going to take 5 cubic second feet out of it once a week for 3 hours. Does that, can the canal company define that as interference or ability to manage and distribute the water?
Sure. The company can give whatever reason they want. And don't get me wrong, if you were to move 5 CFS out of a total 40 CFS, that's a lot of water. And they may be like, hey, look, if we did this for you, it's going to totally affect our ability to deliver water to all of our other shareholders, and here's the reason why. Absolutely, you could do something like that. I think another thing to go along with this question I want to mention that's really important. A lot of times companies feel like if they allow this change to happen, they're giving up the water or they're giving up control. What's really important, when you file a change with our office on these shares, we will create a water right jacket file for it as a bookkeeping item for us. However, this water right is only good if the shares are maintained. And in the end, the company is always listed as an owner on this water right with the person who's the shareholder. And the company is the one who owns the water right. They're ultimately in control of what's going on here. And so just because you allow something to move out of your system doesn't mean that you have essentially sold that off or given it up to go away forever. But coming back to your original question, the company can state whatever the reasons are as to why they're uncomfortable with what a shareholder is proposing.
So let's say 100 acres gets developed and that water doesn't get used on that 100 acres. They get their water for secondary use from another source. After 7 years of that development, can that water be, or does that company have the right to that water just to go to the lake without, or do they lose their beneficial?
So you're asking a really good question. You're asking a question about non-use issues, right? And what happens to the water during non-use. I do think that's going to be covered in a later discussion, and so that could answer that question. I guess what I would say is a couple things. First of all, the best way to protect your water is to use it. If you have concerns that for whatever reason you may be unable to use it, you can file non-use applications on all or portions of your water right and protect it that way. So there's a lot of ways to protect yourself from the non-use clause of the statute, and I'm sure that's going to go over in more depth later. Other questions? Okay, I think I was just about done. After approval, a shareholder may submit extension yet without the company. So yeah, so in summary, water rights are real property. Water shares are essentially a lease agreement between you and someone with real property. If you want to change your shares, so essentially change the way that the company is approved to use them, there is a process whereby you can go to do that. However, the company has to sign off on it. So in the end, here are some questions again to consider. See if you can answer them. If not, we can talk about them here in a second. So when an individual wants to file a change application based on shares of stock in an irrigation company, what must he do? When an irrigation company receives a yeah?
Before you go to the next question, the thing that you alluded to but didn't really state correctly is that prior to generating your proposed change application, you come to our office with your stock certificates and we generate what's called a share statement. You alluded to that, but you didn't put it as one of your steps. So
Yeah, that's a good
in that
point.
first question, that would be step number one. Bring the shares to our office, create a share statement, which is that quote unquote water right that you talked about.
And I should know the answer to this, Eric. Can we create a share statement without having approval from the company first?
Yep. Yes, we can.
Okay, there you go. Okay. Next question. When an irrigation company receives a request to file a change from a shareholder, what should it do? What should the irrigation company do? An irrigation company could incur liability by, is a share the same as a water right? Okay. You guys feel like you have those? Okay.
I probably just spaced off your whole presentation. So you indicated that down the road, the canal company still, you have to after this process, the applicant has to maintain the shares of stock. They're not segregating off a portion of that right for their own use.
So, yeah, I guess this is really important. You're not segregating the right. It comes back to what Eric just talked about. With your shares, we create what's called a share statement, which, if you will, is like a false water right number. And very clearly, it states if you're approved for this change or anything that this false water right number only stays in good standing if you maintain your shares with the company. If the company submits to us a report that says this guy's not paying his assessments, we've taken his shares back from him, that water right will no longer be valid for wherever you moved it to and are using it for.
Okay, so just a hypothetical, because I'm sure it's never happened in the state, is a developer purchases 100 acres of ground, has the shares that were on that ground. He goes and applies to the water company. They don't respond within 120 days. He says, we're golden. We can do what we want to do with that water. So he then changes am I following this right?
You're doing really good
There needs
so
to be
far.
a point of diversion change into the municipal provider. He deeds his shares over to the municipal provider, and then as long as the municipal provider keeps up on those share fees, share allocation, and whatever the fees are, then it's good into perpetuity? I mean, is that kind of the way it works?
I didn't hear a problem with anything that you said, right? Just as the only two things I say, remember that your change application had to be approved by the state engineer, and at some point you still have to submit a proof on it. So municipalities can hold on to water rights for a very long time without, and same thing with a share statement. They'd be able to hold on to a share statement for a very long time without proving up on it. But there's still those two expectations. You'll file a change and eventually submit proof.
So if the developer submits his application, his proposal to the irrigation company, they do nothing, then they can proceed as though it is now approved for municipal use, so long as the division agrees with it.
That's right, and that I would say that is correct. Yes, but remember, you have to provide evidence to us that they did not respond.
Okay.
Right? You'd have to show, hey, I know for a fact that this letter was submitted to them on this date and it was in their possession. It's been 120 days, they have not responded, so here's my affidavit where I'm swearing that I haven't heard from them. Yeah.
Okay.
What if the, excuse me, what if the irrigation company does not respond, but then is a protesting on the change application?
They can do that, 100%. And again, there's a lot of things that go into, right, a change application and a review of protestants and stuff, but it is worth noting that statutorily, it's not just a division rule, statutorily, they had a certain window to respond by, and statutorily, by not giving consent within that time frame, it was deemed as consent. That's not our rule, that's a state statute. So again, attorneys could argue for days and maybe work through it, but that is in state code.
Okay.
Over here.
So if it's an irrigation company and the developer brings it to a municipal for groundwater, then the municipality pays the assessment even though they're using it for groundwater.
So you hit a lot of great things, right? So it's approving, you're assuming a lot, right? You're assuming that we approved you to go from surface to underground, right? But yeah, what was pretty much asked over here is as long as those shares remain in good standing, that share statement is valid and can be used for whatever was approved on the change application. Any other questions? Okay, thank you guys for your time.